Hello, I'm Dan Marr from Hamblett, Kerrigan, Ashford, New Hampshire, and I'm going to be talking in this video today's blog about post-employment restrictions in your employment. So, under New Hampshire law, we generally do not favor non-competition agreements in an employment situation. Employment situation and non-competition agreement is one in which a employer says, don't work in this industry, in this region for this period of time after you leave us. So don't work, and you're working in computers and you can't work in computers for a period of a year after you leave in the New Hampshire area or 50 miles away from our location. Generally, the courts will narrowly construe those to what's called the legitimate business interests of the employer. Legitimate business interests of an employer are generally narrowed down to confidential information or the goodwill. That's traditionally the two things that we deal with in New Hampshire. And the courts, over the decades that this has been going on, there's been a lot of litigation in regards to these non-competes, have narrowed it down to pretty much when you're talking about goodwill, if you're saying I want to protect my goodwill, in most fields, you're going to be dealing with what's called a non-solicitation agreement, which is, even if you call it a non-competition, it's saying don't take our employees. So if you're the general manager, don't go and swoop out, or you're even a well-liked, gregarious coworker, don't be able to swoop out the employees from us and go to another company and convince them to come to your other company. Don't take our customers, don't take our vendors that you've had a relationship with. So primarily with customers, if you're a salesperson or you're in technical support perhaps, and you're really the guy or gal that they get used to, and you're the face of the company. They want an opportunity to replace that face with somebody else, and having the opportunity to do that so that you can't go and take this customer that you used to work with, saying now I'm at this other company. If you still want me, I'm still available, but you have to come over to this company. That non-solicitation is generally enforceable, and the courts will enforce that provision of an agreement that says do not accept business from a customer for a period of, usually it's a year. It could be 6 months in the situation, but that's usually enforceable. So non-solicitation agreements in employment situations are generally enforceable. Non-competition agreements are tougher to enforce. There are certain industries upon which they are enforceable. By way of example, if you're a personality on a TV or radio show, well, in that general area of the listening viewers or the people watching you, you are associated with that news, and they're thinking about John Smith as the radio broadcaster for that area, or that are doing the weather, that they have ties to them, and that type of non-competition agreement is often enforceable in that arena. But generally in the sales arenas and the retails, it's usually restricted down to non-solicitation. Non-competition agreements that are part of an employment agreement are strictly enforceable as long as they are truly confidentiality requirements. So if they're saying that you can't disclose certain company secrets of ours, maybe it's the source code of the software that you're working on, maybe it's the customer list with the details of what the customers need, or it's some other specifics that are not something that generally others can get easily, related to your business, that your competitors would have to spend a lot of time to achieve on their own. That could be confidential information. If you're saying confidential is anybody is our customer base, and our customer client list is everyone that all the other competitors are hitting as well. They're all trying to compete for that same book of business, and you're saying that's a customer list, the court, and that's confidential. The courts will likely look at that and say that's not really confidential. That's just a way to try to get around the non-competition disfavor in New Hampshire, and therefore will restrict it. At least when I've litigated those, I've made those arguments when you have an overly broad confidentiality requirement. But in general, the confidentiality requirements that when we have secret things, don't take them. The courts don't like thieves. You don't steal from your former employer. You have a duty of loyalty to your former employer. You can't take their confidential information and go to another employer and use it against them. So that and the non-solicitation of don't take our employees, don't take our vendors, don't take our customers that you've had a relationship with, those are generally going to be enforced in New Hampshire. We do have a statute that has a provision too that says if you're getting a new job, you have to, before you accept that job, get an actual copy of the non-competition agreement to be enforceable. That doesn't relate to the non-solicitation, doesn't relate to the confidentiality provisions of any type of agreement. It just relates to the non-competition provision. There's a further provision that in the statutes that hopefully not many people are doing this, but it's saying you can't have a non-competition agreement as to an employee who is making twice or less of the minimum wage. And minimum wage in New Hampshire is the federal minimum wage. So if you're trying to get a non-compete from somebody that's making just under $16 an hour, shame on you. You shouldn't be trying to do that anyway. But the non-competition agreements are generally not going to be enforced in that situation. They are not going to be enforced if you just tell them in their offer letter that they're going to be signing a non-competition agreement, but after they accept the job, then you present the non-competition provision. That portion of the overall employment agreement that you give them that's a non-competition is going to be void. But the non-solicitation, the confidentiality, all of that's still going to be in place. So if you have questions in regard to this or other topics, you can contact me at Hamblett Kerrigan at nashwalaw.com, our website, or 603-883-5501.